When it comes to the zoning of oil and gas operations in Pennsylvania, there are two main questions. First, is the zoning regulation consistent with state law, particularly the Pennsylvania Municipalities Planning Code and the Pennsylvania Constitution? Second, is the municipality prevented from regulating a particular oil and gas activity because that activity is regulated by Act 13, the state oil and gas law? The Municipalities Planning Code, or MPC, says that zoning ordinances have to provide for the, quote, reasonable development of minerals, including oil and gas. Pennsylvania has state laws that regulate various aspects of oil and gas activities. Generally, these laws explicitly or implicitly preempt municipalities from regulating the same things in those state laws. The most important of the preempting laws is Act 13. Section 3302 of that Act says that no local ordinance adopted under the MPC shall contain provisions that impose conditions, requirements, or limitations on the same features of oil and gas operations regulated by Act 13, or that accomplish the same purposes as Act 13. But in 2009, the Pennsylvania Supreme Court did weigh in the 1984 Oil and Gas Act, which is the law that Act 13 superseded. Those two cases were called Huntley and Huntley versus Borough Council of the Borough of Oakmont and Range Resources Appalachia versus Salem Township. Broadly speaking, both of these cases were about what types of oil and gas activities could be regulated by local government under their land use ordinances, and what kind were preempted by the Oil and Gas Act. Ultimately, the court indicated that as long as a zoning ordinance has a legitimate zoning purpose sanctioned by the municipality's planning code, then it shouldn't be preempted by the Oil and Gas Act, even if there's some overlap with the purposes of that act. And so the upshot of the Supreme Court's decisions in Huntley and Huntley and Salem, these 2009 cases, is that under zoning laws, municipalities have the power to regulate where oil and gas activities are located, but not how they're conducted. For instance, zoning ordinances probably can restrict oil and gas wells to particular districts, say agricultural districts, and bar them from residential districts, but within the agricultural district, local government can't create requirements on what kind of cement and pipes have to be used when wells are drilled, nor can they say how thick liners have to be for wastewater impoundments. Those features are regulated under the Pennsylvania Oil and Gas Act and the regulations. In 2012, the Pennsylvania General Assembly decided that local governments had too much discretion and power to decide what reasonable development meant. So the General Assembly passed a new oil and gas law called Act 13 that did a lot of things, but one thing it did was state very particularly what zoning ordinances have to do to be reasonable. Among other things, Act 13 said that zoning ordinances had to allow for oil and gas wells and oil and gas impoundments as uses permitted by right in every zoning district, including residential districts. Act 13 required zoning ordinances to allow compressor stations as a use permitted by right in agricultural and industrial zoning districts and as conditional uses in other districts. And it required very fast review periods for applications for zoning permits for oil and gas activities. Act 13 was an unprecedented attempt to force one-size-fits-all zoning requirements for oil and gas on every municipality in the Commonwealth, and to do so in a way that meant oil and gas operations would have had to be allowed pretty much everywhere. Ultimately, though, the sections of Act 13 that imposed these one-size-fits-all restrictions were struck down as unconstitutional under the Pennsylvania Constitution in a case known as Robinson Township versus Commonwealth of Pennsylvania. The court found that Act 13's zoning requirements would have forced municipalities to violate their own comprehensive plans for growth. Act 13 forced municipalities to allow the pig in the parlor rather than the barnyard, the parlor in this case being residential neighborhoods and the pig being oil and gas activities. Later in 2012, the Pennsylvania Commonwealth Court ruled that the zoning provisions of Act 13 violated substantive due process because Act 13's one-size-fits-all approach was an irrational override of local ordinances. Now, substantive due process is a legal concept that essentially means government may not deprive people of rights unless it has a solid, rational basis for doing so. Now, after that decision in the Commonwealth Court, the Commonwealth immediately appealed to the Pennsylvania Supreme Court. But in December 2013, the Supreme Court said that Act 13 violated Article 1, Section 27. It states that the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Municipalities have a constitutional duty to respect their citizen environmental rights, and Act 13 zoning provisions force them to violate those rights by forcing them to allow industrial oil and gas activities in residential neighborhoods and other activities where they just don't belong. Act 13's one-size-fits-all zoning provisions were struck down. They're no longer the law. Local governments have to think very carefully about citizens' environmental rights when they develop zoning for oil and gas. So, the takeaway. Number 1, under the Pennsylvania Municipalities Planning Code, every zoning ordinance has to provide for the, quote, reasonable development of oil and gas. Number 2, what's reasonable for a particular municipality depends on the particular character of that municipality, on where people live and go to school, on all the other uses of land that are taking place in the municipality, and on the municipality's goals for development as laid out in its comprehensive plan and its zoning ordinance. Takeaway number 3. What's reasonable also depends on the constitutional principles discussed in the Robinson Township decision, namely substantive due process and the environmental rights of citizens under Article 1, Section 27 of the Pennsylvania Constitution. These principles act as a check on zoning that's too permissive of oil and gas activities. 4. Finally, local governments can't regulate everything through zoning ordinances. Specifically, they're preempted from regulating most technical aspects of oil and gas operations. What they can and should regulate is where oil and gas activities are located within their borders.